States, both red and blue, are taking up an issue that's divided the country for decades: abortion. Earlier this year, New York State enacted strong new legal protections for abortion rights. State leaders say the move was needed should the Supreme Court decide to overturn Roe v. Wade, a landmark case that established federal protections for the procedure back in 1973. But it's a much different story in many other states, including down south, where states like Alabama recently passed legislation effectively outlawing abortion altogether. The New York Times reports that the national race to pass new laws started last year. That is when President Trump made Judge Brett Kavanaugh his Supreme Court pick. Some believe he may well be a crucial fifth vote as this fight plays out. For more on all of this, we're delighted to have back with us Dan Abrams, ABC News Chief Legal Affairs Correspondent, and most recently the co-author of the book Theodore Roosevelt for the Defense, the courtroom battle to save his legacy. And Dan joins us now for part two of our conversation. Again, always good to have you here.
Good to see you, Jack.
So let's talk some constitutional and political background, if we can here. It's often said that for a president, their greatest legacy may well be the Supreme Court. What's meant by that, and how has that played out for us in the past?
There are few areas that a president has the sole power to influence something as much as the picks to the United States Supreme Court. Yes, there's Senate confirmation, but it is really his choice. And it can fundamentally shape the direction of the country. Now, so far, we haven't had one of these, fundamental game-changing Supreme Court appointments. There's been a slow evolution, no question about it. The court is more conservative today than it was 25 years ago. But still, we're waiting for that big switch, which is conservative. In this case, it would be conservative appointed in place of liberal, that fundamentally changes the balance of the court. And the court has never been so divided in terms of these 5-4 decisions. And so those picks matter more than ever. And in the last, I think it's fair to say in the last 10 years that the picks have become even more important because of that 5-4 divide.
And as we know, a president, even a president's signature legislative success can be overturned.
Yep.
By all of a sudden you have a new Congress comes in and can be dismantled, sometimes thrown out completely.
Yep.
But Supreme Court justices appointed for life.
Yep. Yeah,
They're not going anywhere.
No, it's true. And we talk about foreign policy, the president having enormous power when it comes to foreign. It's true. But you're right. It's temporary. Yeah. You can have a legacy that lasts for 40 years.
Let me ask you to explain one other concept. Yeah. Because as I mentioned in the introduction, Roe versus Wade,
yeah.
1973. And judicial nominees are often, if not always, asked about the notion of legal precedent. Yeah. You and I know the term stare decisis. Mm-hmm. It stands decided.
Yep.
And I suspect that some people might think, well, if it's been decided, you can't undecide it.
Yeah, no.
Technically, explain that to us.
Well, they can do whatever they want. The principle that is applied has been you have respect for previous decisions. And the reason for that is so that you don't have the same situation that you have in the political world, where you get a new president in and suddenly the world changes. The point is that when it comes to something like the court, where you want a level of dependability, you want a level of consistency, and you want, most importantly, respect for previous decisions that have been made. But there are certain justices who are on the court right now who have, basically said, I'm not really that concerned, Justice Thomas being one of them, with what the precedent is. It seems that Justice Gorsuch is probably going to be part of that block as well. But I think that those who think Roe versus Wade is going to get overturned are mistaken. Meaning, this is why the Alabama law, I think, is a problem for pro-life, not pro-choice, which is the Alabama law.
And a lot of people might find that unusual.
Right,
you're saying that.
It's the harshest law in the country.
And I agree with you. So
right?
explain why.
It's the harshest law in the country. No games. No, we're doing this to protect the mother. We're doing this to ensure that they have hospitals. There's no effort to wink and nod here. This is saying we are banning abortion, period. And up to this point, there's always been arguments about, well, come on, consent on the part of parents, or should there be a consent of a husband, or
waiting period,
or making sure that no one is getting an abortion based on the race or the sex or gender of the child, et cetera. And those are all, there is a other side to all of that. And so it allows those who oppose abortion to say that we are just imposing what is not what's called an undue burden.
Right. And those are the magic words, the evolution, and the court case recently said, there can be some restrictions as long as they don't create an undue burden.
Right, which, that was the Casey case in 1992. And the question becomes, what does that mean?
Yeah.
What is it?
That's why you continue to have litigation.
Exactly.
People often say, why isn't this settled? And the answer is, what's an undue burden?
What is an undue burden? But you know what? Alabama's not pretending. Yeah. And so it's the kind of case where even Pat Robertson says, well, this has gone too far. When Pat Robertson says it's gone too far, there's a reason. He gets it. He knows it's a possible problem for them. And so the more dangerous cases for the pro-choice side are the ones that will just chip away, slowly make it harder and harder and harder for women to get abortions in particular states.
You often hear people involved in litigation say, okay, we're taking our case to the Supreme Court. As if every case gets to go to the Supreme Court if you as lawyers say, yes, we wanted to go to the Supreme Court. What's the reality in terms of how often cases actually get to the Supreme Court, and what is it that draws the justices' attention to make them say, okay, we want this one?
Well, as you know, the vast majority of cases, the court will say we're not hearing it, and that means that the lower court opinion is effectively affirmed. There's no question.
I think the number might have been last year around 10,000 applications, and they heard 70 cases?
Yeah. But there will be an abortion. I mean, there's no question there's going to be a number of, at least, I shouldn't say a number, there's going to be a big abortion decision in the next couple of years. It's going to have to happen. Which of these cases it's going to be? There are all sorts of different state laws with different restrictions, and my guess is they'll combine them to some degree, and maybe implement a different standard. But people should know that there was a Louisiana case recently where the lower court had actually ruled that a very tough Louisiana law was okay to implement. So trial court had said, no go. Appellate court said, we don't think it's an undue burden. And the Supreme Court issued a stay, meaning enough of the justices basically said, we're going to hold off on letting them implement this law. It was Roberts and the 4 liberals, and even Kavanaugh said while he would not have granted the stay, he wanted to know more about what the burden would be. So Kavanaugh, I mean, look, do I think that Kavanaugh is going to be a pro-choice justice? Absolutely not. But when it comes to overturning Roe versus Wade, I don't think you're going to have Roberts, and I think Kavanaugh would be more reluctant than some people think. So, to purely overturning Roe versus Wade.
The Alabama case.
Yes. Or any of these cases basically say we're going to ignore Roe versus Wade from now on, and states can do what they want.
We always learn a lot more when we chat with you about these things than before you come in and join us, and there's always a lot for us to talk about.
We could turn this around, and I could be asking you, and you'd know it better.
You and I have done that before, but it's always fun when I get a chance to get together with you and we do all that.
Absolutely.
Pleasure as always. Again, I want to mention great book, Theodore Roosevelt for the Defense: The Courtroom Battle to Save His Legacy. Make sure folks take a look at that. Good seeing you. We'll talk again soon.
Thanks, Jack.